The YNW Melly murder trial is officially delayed. The prosecution has filed an appeal, which has subsequently put the trial to a complete standstill. So yeah, I haven't updated on this trial in a while because not much has been happening, but it's delayed again for the millionth time. This time it's because the state is trying to change shit that the judge ordered on. So I'm going to read it and explain it to you guys the best I can understand it. It has to do with that promotional documentary that Melly put on his YouTube channel. So yeah, let's get right into this video. Hit subscribe. Here we go. State of Florida versus Jamel. Notice of appeal. Notice is given that the state of Florida appeals to the 4th District Court of Appeal. So it looks like there's 3 things they're appealing. The non-final order suppressing evidence as noted in the omnibus order on defendant's motion to suppress evidence 1 through 13. So I think they're appealing the window that the judge gave on certain pieces of evidence like the Snapchat, the phone records, all that. Because he gave a new window of time frame between 3 a.m. and like 6 a.m. or no, 3 a.m. to 9 a.m. is what he gave on some of the evidence, which shoots down a lot of what the state had. And then the second thing they're appealing is the non-final order of this court denying the state's motion for reconsideration of the court's omnibus order on the defendant's motion to suppress evidence 1 through 13 as noted. Okay. Third, the non-final order of this court granting the defense motion in limine the promotional video. The nature of orders 1 and 2, as reflected above, are the granting of the following non-final orders noted in the omnibus order suppressing evidence, as well as the denial of a non-final order denying the state's motion for reconsideration. So to dumb this all down, it sounds like the state's salty about the judge's orders, and they're saying no, and they apparently have the power to pause this entire trial and put in an appeal, and that has to go to a higher court. The 4th DCA, partially granting the defense motion to suppress his iPhone X iCloud account, his Snapchat, the Facebooks, his Instagram right here too, iPhone X, his emails, and then another email. So this is the time frame the judge gave, 3 a.m. on October 26, 2018 to 9 a.m. on October 26, 2018, which is basically like a 6-hour window surrounding the time frame when the murders happen. The state doesn't like this. They don't want this time frame. They want to have way more leeway on this time frame to get more evidence to make Melly look like he's guilty. Essentially, that's the whole point. They're trying to show the whole picture, essentially. So he did this with the emails too, and that was a big one because I believe a lot of the gang affiliation with Melly emailing gang affiliates, like the whole rule book of the Bloods and his email and shit being emailed to him and him like replying back, talking to the Blood, saying herc and shit. They can't use that now, essentially, but they're going to be able to use a lot of his Instagram and pictures of him anyway. So here's the order granting defense motion eliminate promotional video. Defendant moves to prohibit at trial a specific portion of the promotional documentary video from coming into evidence. The portion at issue in this order is a 14-second portion. From 2014 through 2027 is the timestamps, where the video depicts the text 4 days after the completion of this film. YNW Melly and his friends were targets of a drive-by shooting in Miami, Florida. YNW Juvie and Sack Chaser were killed. That portion also shows the defendant standing in the background. Defendant claims that this clip from the video is inadmissible at trial since the text included therein is hearsay and double hearsay, not attributable to defendant and irrelevant. The state claims that this clip is an adoptive admission, an exception to the hearsay rule under section blah 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 Florida statute. The court agrees with the defendant that this 14-second portion of the video is inadmissible at trial. The text displayed on the screen is not attributable to any specific person. So the judge is agreeing with what Melly seems saying, that whoever wrote this text on the screen saying Melly was present in the car, it doesn't necessarily mean it was Melly typing it. Like it could just be an editor of some kind. While this short video focuses on the defendant's life, it is mere speculation to guess who decided to add the text statement at the 2014 mark. Could have been the director, producer, editor, defendant, or any number of people. Thus, without knowing the source of the comment, it holds no evidentiary value. Judge is kind of snapping on this one. I mean, we all got to agree with that. We don't really know who typed that, and I highly doubt it was Melly that typed that. I mean, you think Melly's out there editing a documentary? No. Next, this court finds the state's argument that this text statement in this clip is an adoptive admission by the defendant to be without merit. For an adoptive admission to be considered an exception to the hearsay rule, it must be a statement that is offered against a party and is a statement of which the party has a manifest adoption of belief in its truth. The f does that mean? I don't know. Merely because the entirety of the video was posted on defense YouTube page does not make everything contained there on an adopted admission. Oh, so they were just saying because it's on his own YouTube page, he said it. It was him. It's on his YouTube page. He wrote it. I get it. It does pretty much say that he was in the car, and I guarantee whoever wrote that, the editors regretting writing that. As the 4th DCA pointed out in Phillips Morris, USA, when an adverse party manifests a belief or adopts a statement as his, and the statement is treated as an adoptive admission under section blah, blah, blah. An adoptive admission occurs either when there is a direct expression of an adverse party assenting to the statement of another. All these big words, dude. Like, just say, what are you saying? I feel like I'm a idiot reading this shit sometimes, dude. In the instant matter, with regard to the text of the 2014 mark, there is certainly no direct expression by the defendant assenting to that statement. Furthermore, the act of posting this video on his YouTube site is not conduct circumstantially indicating his assent to the truth of that particular statement. Okay. The statement is neither attributable to defendant nor do the circumstances demonstrate his adoption and assent to the statement. The evidence points to nothing indicating defendant manifested an adoption or belief in the truth of the unattributed statement. Thus, the text at 2014 through 2027 remains inadmissible hearsay. Jesus. All right. So the judge ordered this on January 25th, right? At 7:30 in the morning. He did this at 7:30 in the morning, right? The appeal that I read earlier in this video was sent in at 2:16 p.m. right here. They filed this at 2:16 p.m. So they did not waste no time, bro. They put together a 50-page document within like 6 hours or so, appealing this to the 4th District Court of Appeals. Like, what the they are not playing games, dude. This new prosecutor, it might have been a mistake getting a new prosecutor in this case. Like, Alexandra Bruckaloo and Harold F. Pryor do not play games, bro. Notice of cross appeal. Jamel Demons, defendant, cross appeals to the 4th District Court of Appeal. The non-file orders of this court. This cross appeal is limited to related issues resolved in the same order as being appealed by the state in the notice of appeal. So I think what they're doing is saying, we're going to appeal what you're appealing. I think. So it looks like they list all the orders partially denying certain things. So what I think is Melly's team is going for here is they want them all to be granted. Like, they're like, we don't want these to be partially denied either. We want everything else to be granted. So they're going for everything, basically. They don't want any of this evidence in the trial. The Facebook, the Instagram, the phone, the Snapchat, iCloud. They're going for the whole, they're putting their nuts on the table, boys, essentially, is what it looks like here. That's my understanding of all of this, even though it's using big words, and I did not go to law school. It's funny, people always like comment, like every once in a while I get a comment saying like, this kid doesn't know what the fuck he's talking about. Yeah, I read it and I analyze it from like a normal person perspective and try to like help normal people understand what the fuck is going on, because I didn't go to law school. Like, obviously, I'm a ginger kid. Makes YouTube videos, bro. This is for entertainment. So this is just an order by the court saying that Melly's team has to pay this $295 filing fee, or else they can't appeal this shit, essentially. And this is crazy, bro. 5 years later, we're getting this. Acknowledgement of new case. 4th District Court of Appeal has received a case initiating document reflective of filing date of February 16th. How exhausting, bro. Holy shit. Respondent shall file a response within 20 days from the date of this order and shall cause why petition should not be granted. Petitioner may file a reply within 10 days of service of the response. Okay, putting them on a little time frame constraint of some kind. So this is a documentary that is in question. I don't remember in the first trial if they showed some of it or not, or maybe it was a small clip of it to the jury, but I know it was discussed in the first trial. I remember it. Throughout this documentary, I mean, it's talking about him like being obsessed with guns and loving guns and shit. So, and he's holding like an AK-47 and like shit that probably shouldn't be shown to the jury. That's Juvie right there, who Melly allegedly, killed. And their sack chaser. All throughout this documentary of them all three hanging out together. Showing this to the jury is going to be very confusing. They're going to be like, wait, what the fuck? They were this close? Like, if they can hear all of what they're saying, they're like best friends. Like, laughing and chilling. So that's a gun laying on his bed next to him, next to his phone. Literally in a Draco.
I seen some shit shining. It was a 22 revolver, a real gun. I'm a kid, though. So I just walk out the house and I shot that bitch. And I couldn't hear out my ear for like a week. But then I was like, damn, this is a real gun, you know what I'm saying? I was only in 4th grade, but I took that bitch everywhere. To school, I took that bitch everywhere.
Yeah, show that to the jury, it's over. Like, come on. He took that bitch everywhere. A gun to school in 4th grade. I mean, if they use his lyrics against him in this video, just these lyrics in video, is not a good look to the jury, bro. So here's the part in question right here. 4 days after the completion of this film, YNW and his friends were charged with a drive-by shooting in Miami. Juvie and sack chaser were killed. So the state is saying that this is an adoptive admission. The judge is saying it's not an adoptive admission and that the 4th DCA has already ruled on this before. So I see this not going in favor of the state, essentially. If the 4th DCA has ruled on this before in another case, this seems like a huge waste of time. And I feel like it could be them stalling. Like, it could be the state stalling for more time because it's 2 new prosecutors on the case or whatever, and they're trying to just have more time to collect everything and figure out how they're going to approach the trial. That's been one of their big complaints, is like, we can't start this trial this soon. We're just now getting started on this case. But yeah, comment down below what you guys think. I think this is a stalling tactic for the state, and they know they're not going to win this appeal. And yeah, hit subscribe. Love you guys. It's a damn shame. 5 years. 5 years waiting for a trial is crazy, to be honest. So yeah, peace out, boys.